I'd first like to introduce myself. My name is Nathaniel Chu. I'll be your first affirmative speaker in today's debate round. Thank you so much for taking the time to judge.
My name is Luke Buck. I'll be your second affirmative speaker. Again, thanks so much.
My name is Nathaniel Kolssak. I'll be your first negative speaker, and just so everyone in the room is aware, I'm a type 1 diabetic, so I'll have this device on the table. It measures my blood sugar levels. It might vibrate occasionally, so please don't let that distract you.
And lastly, my name is Caleb Koch. I'm going to be your second negative speaker. Thank you to the three of you for taking it down this morning.
Now, before we get started, I'd like to just...
Are all my judges all set? Okay, we can go ahead and get started. Angel L. Morales was convicted of, quote, conspiring to commit money laundering and was sentenced to 151 months of imprisonment, which he began serving in February 1999. 3 years later, the Seventh Circuit issued a decision that reinterpreted the federal statute used in the conviction of Morales. This decision was necessarily retroactive and rendered Morales innocent, unquote. Thus, Morales was now in jail for a non-existent crime. And rightfully, he tried to pursue justice through something called a habeas corpus petition. However, Morales, though innocent, remained in prison for over 10 years because he would never receive justice because of the law called the Anti-Terrorism and Effective Death Penalty Act of 1996, or the AEDPA. Now, before we get into the problems with the AEDPA, I'd like to give you some background knowledge behind this habeas corpus petition. Definition: habeas corpus. Defined by Columbia Law Review, quote, habeas corpus is a petition that you can file in federal court to claim that your imprisonment violates federal law. A federal habeas petition claims that your imprisonment is illegal because your arrest, trial, or actual sentence violated a federal statute, treaty, or the United States Constitution, unquote. Essentially, a federal prisoner files a habeas corpus petition to question the legality of his sentence and can be used in many scenarios. For example, if the law used in your conviction has been changed, your lawyer had violated your constitutional rights, or you have found evidence that can prove your innocence, you can file a petition to fix these injustices. But in order to fully understand our case, there's another key term that is vital to remember. The federal law for habeas corpus is specifically known as Section 2255. Section 2255. And these two terms will be used interchangeably throughout this debate round. Now, this takes us to our fact. The AEDPA puts a 1-year time limit. AEDPA puts 1-year time limit. The Texas Criminal Defense Group, experienced criminal defense attorneys based in Texas, wrote, quote, the AEDPA is one of many pieces of get tough on crime legislation that Congress passed to favor prosecutors at the expense of the accused and the unjustly convicted. Sold as reform legislation to cure a non-existent problem, the AEDPA hampers the ability of wrongfully convicted defendants and those who are convicted after unfair trials to regain their freedom. The AEDPA reformed habeas corpus by limiting its effectiveness. The most troubling changes require a prisoner to raise all claims and one collateral attack within a year after the prisoner's conviction became final, unquote. When Congress passed the AEDPA in 1996, it severely restricted the rights for prisoners to file a Section 2255 claim by establishing a 1-year time limit called a statute of limitations. A statute of limitations. And this put a 1-year time limit for a prisoner to file a 2255 motion regardless of how unjust a punishment could have been. After that 1-year time limit has run, a prisoner is barred from ever filing a claim for habeas corpus. A time limit on justice is unconstitutional and unjust. Today, Luke and I present a plan that will bring justice to the innocent and even the guilty. The main principle behind our plan is justice, which we believe is giving every man his due. But unfortunately, the United States has failed to face this injustice in our society. Thus, we stand resolved. The United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. And for that reason, we present the following plan. Our mandate is simple. Remove the 1-year statute of limitations in Section 2255 of the United States Code, Title 28. Our plan will be passed immediately upon affirmative ballot. No funding is needed as this plan is purely legislative. Our agency enforcement is Congress, the Supreme Court, and any of the necessary bodies. And it's also important to note that their plan is a comparative advantage case, which means we recognize that there's no such thing as a policy that completely overhauls all the injustices in the federal prison system, and we don't claim to do so either. But what we can guarantee is that through our plan, will better allow for federal prisoners to have access to justice, thus providing a net benefit to the current system. Now, there are two reasons why an affirmative vote is needed. A time limit on justice is unconstitutional. Justification 1, unconstitutional. The founding fathers created the Constitution as a foundation for laws, rulings, rights, and ultimately our country. When the courts and the justice system fail to abide by its own constitution, it strips away the very purpose that the system was set up. The AEDPA violates the Constitution by putting a 1-year time limit to file a habeas corpus petition. Lawrence Daly, a judicial attorney at the Supreme Court of Ohio, wrote, quote, "The writ of habeas corpus has become the last call for prisoners contesting the legality of their sentences or convictions. The United States Constitution protects the rights of habeas corpus relief in its suspension clause. Quote, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it, unquote. Article 1, Section 9, Clause 2 of the Constitution provides exactly two reasons why the right to submit a habeas corpus claim can be suspended. Number 1, when in cases of rebellion, or number 2, invasion. However, in the current system, these rights to seek a habeas corpus claim are being denied simply because 1 year has gone by. Denying a person's right to seek justice through habeas corpus cripples their constitutional rights. But arguably, more important, justification 2, unjust. We believe that justice is giving every man his due. But oftentimes our justice system ironically fails to give justice. The sad reality is that the innocent are convicted, and even the guilty are receiving undeserving punishments in our country right now. In order for someone to pursue justice and show that a sentence is unjust, federal prisoners have to file a habeas corpus claim, but the AEDPA bars prisoners' access to justice. A Harvard Law Review published in 2016 exposed the injustice of the statute of limitations, saying, quote, a review of the AEDPA's history reveals that its changes were intended to reduce the number of petitions filed in district courts, to ensure that with vanishingly few exceptions, a prisoner could not challenge even the most unjust of convictions after the statute of limitations had run, unquote. Think back to the story of Mr. Morales. He was in jail for a non-existing crime, and thus he rightfully pursued justice and tried to file a habeas corpus claim. However, he was unable to file a claim for one reason and one reason only. The AEDPA's 1-year statute of limitations had expired. The most unjust and sad reality of this is that 2 other people who committed the same exact crime were convicted of them. They both filed their habeas corpus claims before the 1 year, found innocent and released from prison. Unfortunately, Morales, though innocent, remained in prison for over 10 years because he failed to meet an unconstitutional and unjust deadline. More and more people will continue to be barred from justice because of this unnecessary deadline. But with your help, there will no longer be a time limit on justice. Thanks so much.
3 minutes on the clock here.
Yeah.
The judges are all set. First of all, Nate, congratulations on making it to quarterfinals. I do just have a few questions. So first of all, in general, you're saying that the statute of limitations creates what you might call sort of a problem with the whole way of life inside of prisons.
That is correct.
Okay, so now can we establish that you must have a significant harm in the current system? You must prove that.
I believe the job as the affirmative team is to, number 1, uphold the resolution, but also bring a net benefit to the
All
current
right,
system.
net benefit. So that contains a significant advantage per the resolution's wording, correct?
Not necessarily, but our plan does provide a significant advantage to the current system.
Okay, wonderful. Now could I get a copy of your 1AC and hand it back to my partner? Thank you. Now, can we agree that a normal appeal would be different from using habeas corpus, correct?
That is correct.
All right, and they can go through the appeals process if a prisoner does so before filing habeas corpus, correct?
That is correct.
All right, now, how many cases have been thrown out unjustly because of the 2255 statute of limitations?
So yeah, so that's a great question. Now in 2020, there was around 526 petitions filed for the section 2255 motion. And around a quarter of those cases are being denied solely because of the statute of limitations.
Understood, so a quarter of the 500. All right, now my question specifically was how many were unjustly thrown away?
I believe that quarter is all unjustly thrown away because every single prisoner deserves the right of habeas corpus relief under the suspension clause of the Constitution.
All right, we'll talk a little bit more about that, but we don't know how many were thrown away unjustly. You're simply saying it is unjust because it was a suspension of the writ.
So essentially, they throw away the case because of the statute of limitations, regardless of taking into account the merits.
But we don't know if those were frivolous or meritorious cases. It was thrown out before it was judged, correct?
Well, obviously, if it had not actually gone to the court, we would not know if it's unjust.
All right, and you can agree that they do go through an evidentiary hearing, correct, in every single situation?
I would not necessarily agree with that. If it is beyond the statute of limitation, then it would be rejected.
Now, is it your claim that all statutes of limitations are unjust because they suspend the right of access to court?
No.
No. Now, can we agree that nearly all civil law has statutes of limitations?
So we're specifically taking a look at this statute of limitations, and we're saying this is an unconstitutional and unjust practice because the Constitution specifically is talking about habeas corpus in this.
And it talks about a suspension, so let's talk a little bit about that. So you're saying the Constitution says that the writ cannot be suspended, correct?
That is correct.
Could you define a suspension for me?
So essentially blocking or essentially denying this person's access to the court because of, regardless of whether it's invasion or rebellion.
And can we agree that suspension would be a complete block, correct?
That would be correct.
All right, now, has the AEDPA or the 2255 statute, has it ever been evaluated in a court on its constitutionality?
So regarding the statute of limitations, it's not actually been evaluated in the Supreme Court, but we can take examples from Wolfe v. McDonald, which ruled that prisoners' access to courts cannot be obstructed.
Has the AEDPA, where the statute is found, has it ever been heard in court?
For the AEDPA, I believe it has gone to the Supreme Court, but not specifically the statute of limitations.
All right, thanks so much, man, I appreciate it.
Said. My great-grandpa was a fixer. He loved to fix all kinds of things. And I remember a story that my mom told me one time. That he took their entire car apart in the interest of tinkering with it and making it better. And in the end, after he put it all back together, it wouldn't start. You see, sometimes in the interest of making things better, we end up making them worse. It ultimately shows the principle that if it isn't broke, don't fix it. Or if it ain't broke, don't fix it. In this speech, I want to go over what the affirmative has talked about, because they've painted to you a very convincing picture that there's unconstitutionality and injustice in the current system. But is that actually the case? Well, we'll look at that through a couple of different ones. The first thing is I'd like to present the standard in today's debate round, which is the idea of justice. And I believe both teams can agree to this, is that we want to prove that justice is upheld through the system. With that being said, I've got one main point, and I'll be tackling the issue of justice, and Caleb will be looking at the issue of constitutionality. So first, looking at the issue of justice. I believe it's important for us to understand where this idea of habeas corpus originally comes from. So this is the first point here, is the background of habeas corpus. A habeas corpus petition is something that was enshrined in our Constitution, and I believe Article 1, Section 9. Now underneath this right of habeas corpus, essentially it was meant to stop wrongful imprisonment. But the background on that is that in other countries before the United States, in places like England, kings would imprison people without any trial, without any way to prove their innocence. And so it was a carryover from a previous decade, or rather previous time, in order that people could actually prove their innocence. So the idea here is that innocent people are not imprisoned, and that's the purpose of habeas corpus. So are innocent people imprisoned? Let's look at the justice of this system. The first thing I'd like to look at here is when the clock actually starts, because there is a one-year statute of limitations on these appeals. But when does that clock specifically start? According to Brandon Sample, attorney at law, he said on October 30th of 2020. The first trigger starts at the AEDPA clock is on the date in which your judgment becomes final. But when is a judgment final? In Gonzalez versus Thatcher, the Supreme Court settled the question and held that a judgment is final when all options to appeal have expired or all appeals have been denied. So here's what we can effectively see, is that underneath this statute of limitations, it specifically only starts after all appeals have been filed, and this process can take a very long time. Individuals can go through multiple steps of an appeals process, and the clock only starts after every appeal has been reached or denied. The next thing we can look at here is the idea of that the courts can actually restart the clock. And this again comes from the Brandon Sample attorney law firm. And they said the fourth provision was for restarting the 1-year clock on the date in which a fact of supporting a claim or claims presented could have been discovered or discovered through the existence of due diligence. Federal prisoners only have to show a discovery of facts supporting a claim. The Supreme Court's instructive case on the fourth provision, Johnson versus the United States, where the court recognized that vacated prior convictions as a new fact to restart the AEDPA. Now that was kind of a complex piece of evidence, but here's effectively what it says. Now under the AEDPA, the clock resets when new facts are brought to light. So an individual who is actually innocent and who has evidence to prove that innocence, that they're wrongfully imprisoned, even if the 1 year has expired, that clock resets after the finding of new facts. And as such, there is a way that their case can be heard. The next thing we'll look at here is the fact that the courts can specifically actually delay this clock or restart this clock. This is from the National Post-Conviction Project. And they said the AEDPA's 1-year rule is not hard and fast in every circuit court has the right to consider the issue ruled, that it is not jurisdictional in its nature, and is therefore subject to equitable tolling, which excuses a movement's untimely filing because of extraordinary circumstances that are both beyond his control or unavoidable even with diligence. And again, there's a lot of complex legal things that will be tossed around in this debate round, but I'll do my best to try and explain. Effectively, what this piece of evidence is saying is that the court has discretion. That when there are circumstances beyond the individual's control, that time limit can be stopped, it can be suspended, it can be restarted. And as such, the statutes of limitation are not unjust because prisoners' cases can still be heard. But the last thing I want to bring up here is the actual innocence standard. Actual innocence standard. Now, against all of this, even if they've failed to meet the 1-year time limit, even if they've brought new evidence and that time limit has restarted and they failed to meet it again, the actual innocence standard still applies. And I'll explain it first and then read the evidence. But actual innocence effectively means that if the individual did not commit the crime, they are actually innocent and can provide evidence to prove that, they can still be released under a habeas corpus petition. This comes from, again, the Brandon Sample attorney at law. And they said the statute of limitations found in 28 U.S. Code, section 2255, potentially implicates the suspension clause. Courts have generally deemed that 2255 statute of limitations does not implicate the suspension clause, but there is a case where it might, which is actual innocence. So here's effectively what that's saying, is that underneath this, courts have ruled that if it violates actual innocence, it ultimately violates the suspension clause. But these individuals are able to bring new facts and new materials, and as such, it doesn't violate the suspension clause. And Caleb will go more into detail of the constitutionality of this case in his next speech. But I'd like to talk more importantly about how their plan will actually create injustice. If justice is our final goal in today's debate round, and I'm showing you that individuals are able to have their cases heard under the AEDPA and the statute of limitations, let's talk about how their plan further creates an injustice. The first point you can write down here is the purpose of statute of limitations. Now, a statute of limitation is not a rare thing for our legal system. It actually exists all over our legal system. And specifically, we can see that it exists in every civil or nearly all civil actions. This is according to the Corporate Financial Institute, a financial analyst certification organization, and they say nearly all civil actions are subject to statutes of limitations. But here's why. Statutes of limitations are incredibly important. They're in place for a reason, so that individuals can't bring up cases from decades or even longer in the past, because a timely fashion is required in our justice system. This is from Andrew T. Broke, an attorney at law, and he said on May 13th of 2022, statutes of limitations are intended to protect people from false claims and poor record keeping. When most statute of limitation laws were first enacted, victims could create legal cases decades after the initial accident. Here's what we can see. Statutes of limitations are important to protect our justice system. They're in place for a reason, and that's exactly why the AEDPA has put in place this 1-year statute of limitations. But again, that's not a hard and fast rule. With the last few seconds here, I want to talk about a major disadvantage, which is about this injustice. Now, by removing this statute of limitations, here's what you're going to be effectively doing. You're going to flood the court with maybe frivolous, maybe meritorious cases, and here's exactly what that looks like. The Department of Justice did a study in March of 1972, and they reviewed state prisoner habeas corpus petitions filed between July 1st, 1975 and June 30th, 1977. Here's what they found. That 3.2% of the petitions were granted in whole or in part, and only 1.8% resulted in any type of release of the prisoner. Only 3.2% of habeas corpus claims are successful, and those claims can still be heard in the current system. We can see one clear thing from this speech, that the current system is not unjust. Thank you.
Judges ready? We can go ahead and get started. Great speech, Nathaniel, and congratulations on making it to quarterfinals.
Thank you.
I just have a couple of questions for you. So first of all, can we agree that the innocent should never be in prison under any circumstance?
Sure.
Okay, and can we also agree that justice is giving every man his due?
Yes.
Okay, and you talked a lot about the new facts can restart the time limit, but regardless, it's still a 1-year time limit, correct?
Right, so you have 1 year originally from the filing of the case, and then if you have new facts, it's yet another year that's given to that time limit. So saying it's 1 year, like in actuality, yes.
Can we agree that in the case of Angel Morales, his time limit did restart, but that 1 year was not enough for him?
Yeah, so in that one case, there may have been injustice, and that is truly a sad example, but that doesn't prove a widespread problem.
And can we agree that the statute of limitations was the sole reason why he was not free from his imprisonment?
That may be true, and in that one case, it may have been unjust, but that is not enough to warrant a policy change, and it's your burden to show.
And the innocent should never be imprisoned under any circumstance.
That again is true, but one case does not warrant a policy change as we are replicating Congress in today's debate.
Moving on to my next question, you talk about equitable tolling. So what is the criteria for equitable tolling?
Well, essentially, it's saying that the court has the discretion on delaying the law.
But it must be an extraordinary circumstance, correct?
That is what the evidence said.
Okay, and can we agree that it's rarely given?
It may be rarely given, but I believe you have to show that.
Okay, moving on to the next point, you talk about actual innocence. So what is the criteria for actual innocence?
So actual innocence, and I have a piece of evidence here, I didn't get to read it in the round as of yet, but it talked about how when there's evidence, trustworthy evidence, an eyewitness account, something along those lines that proves your innocence, then that can be heard.
Would you agree that you have to prove that no reasonable juror would find you guilty under your evidence?
Yeah, it's essentially that.
So that's a very high criteria, correct?
Of course, and innocence, specifically for those who have already been proven guilty.
Sure.
I believe there should be a higher standard on them to prove that.
Can we agree that actual innocence applies to innocent people, but not all innocent people can apply for actual innocence?
I'm a little bit confused by the question. Anyone who is actually innocent and can prove that they are
But
actually
because of the high
innocent.
criteria, some people who are innocent cannot meet that criteria.
Well, I believe you have to show that.
Sure. Can we also agree that actual innocence is rarely given?
Again, you'd have to show that as the affirmative.
Okay, and can we also agree that an exception to an unjust law will not justify that law?
So I wouldn't necessarily say that the law is unjust. Statutes of limitations exist all over the United States, and just
But
because
just
it's
in
a
general, an
limitation,
exception to an unjust law won't justify that law.
I suppose you could generically say that, but again, I think there's instances or specific laws that we have to look at specifically with this case.
And is justice giving every man his due, not just in extraordinary circumstances, and not just in when no reasonable juror would find you guilty?
So those aren't the only reasons. If you have new evidence or new facts,
But
justice
justice
can
is
still be
giving every
served.
man his due, correct?
Individuals need to prove their innocence after they've been convicted, and that's the standard that the court holds to.
All right, thanks so much.
Between the time that Perkins' conviction became final, he obtained 3 affidavits which pointed to Jones as the real murderer. However, Perkins did nothing with them until June of 2008 when he filed a federal habeas corpus petition alleging that the affidavits constituted as newly discovered evidence of actual innocence. The United States District Court denied Perkins habeas relief because Perkins had waited years from the time of his conviction and consequently could not satisfy the diligence requirement. End quote. Even though Perkins had eyewitnesses confirming on oath that someone else was the real murderer, he was denied access to prove his innocence simply because a year had gone by. Now, if the statute of limitations is denying people access to justice, one might speculate, why was the statute of limitations even adapted in the first place? And the answer is preventing federal court clogging. Now, obviously, federal court clogging is a very serious problem. And because federal prisoners use the federal court system, the AEDPA, and consequently the one-year statute of limitations, was aimed to curb the amount of litigation filed by federal prisoners. Now, though the intentions were noble, the results displayed a completely different story. The statute of limitations failed its goals. According to Prison Legal News in June of 2021, quote, the one-year statute of limitations was a last-minute addition that had no prior basis in Supreme Court decisions, and most scholars agree it was not needed. The statute of limitations actually increased the number of petitions filed by prisoners out of fear that they would be forever barred if they did not file within that one-year period. This has forced the courts to address kitchen sink petitions, perhaps wasting more of the court's time, end quote. And this goes in direct response to the argument that Nathaniel made in his last speech, essentially, that we are flooding the courts with frivolous litigation. And really, two impacts can be derived from this card of evidence. The first being that the one-year time limit actually increased the number of petitions because it forced a sense of urgency upon these prisoners. But furthermore, the second impact is that as a result of the time constraints, the quality of petitions became more frivolous, rendering many of the cases a waste of time to the federal courts. Now, I'd like to respond to some points brought up by the negative speaker in their last speech, and then further emphasize on our justification that are unconstitutional and unjust. So the first point of argumentation brought up by the negative team was essentially all these exceptions, and he brought up discovery of new evidence, equitable tolling, and actual innocence. Those are the three exceptions that they brought up. And I just have two general responses to any exception to the statute of limitations. My first general response is that an exception to an unjust law does not justify that law. And I believe Nathaniel agreed to this in cross-examination, that he doesn't really believe our plan is unjust to begin with. But if the law was unjust to begin with, an exception to that unjust law does not justify that law. But furthermore, my second response is that there are still hundreds denied access to justice every year. This was stipulated in the first cross-examination when they asked my partner how many individuals are denied because of the statute of limitations, and it is hundreds every single year. Now, I'd like to get into specific responses regarding their points of argumentation. Now, the first point was essentially talking about when there's a new fact, the time limit actually restarts. And my response to this is twofold. The first being that Angel Morales was still blocked. In the 1AC, we quoted a story of Angel Morales, and he discovered that the law had changed, so that reset the time limit. But he was still blocked because sometimes individuals lack the proper resources to mount an effective challenge within that 1 year. So innocent people are still blocked. But furthermore, my second response is that it is still 1 year. It's still 1 year, the time limit is still there. It's not like they have unlimited access to justice. The time limit is still there, and they can still be blocked within that period. Now, the next point of argumentation, or next exception brought up by the negative team, was this idea of equitable tolling. And my response to this is, again, twofold. My first response is Floyd Perkins. You can look to the story of Floyd Perkins, the man that I introduced in the beginning of my speech. He tried to file for equitable tolling, but was denied. He was denied because the standards of proof for equitable tolling are so incredibly high that he cannot possibly fulfill it. But furthermore, my second response is that it is rarely ever given. Equitable tolling is rarely ever given. According to the law office of Paul D. Prazzulli, copyright 2021, they noted that, quote, the 1 year statute of limitations may also be halted through equitable tolling. Equitable tolling will excuse one's untimely filing because of extraordinary circumstances that are both beyond a defendant's control and unavoidable even with diligence. However, such relief is extremely rare, end quote. It is extremely rare that individuals actually qualify for the standards for equitable tolling, and therefore hundreds of individuals are still being denied access to justice and having their lives ripped away every year simply because a year has gone by. Now, the final exception brought up by the negative team was the actual innocence requirement. And again, I have two responses. First of all, Floyd Perkins. Floyd Perkins not only tried to file for equitable tolling, but he also tried to file for actual innocence. And he was an innocent man, but because the standards of proof are so incredibly high to fulfill actual innocence, he was still denied. And finally, my second response is that only a handful of individuals actually apply for actual innocence. According to Prison Legal News on September 15 of 2013, quote, in McQuiggan v. Perkins, the United States Supreme Court held that actual innocence, if proved, is a gateway through which a habeas petitioner can make it into the federal court. However, the standard of proof for actual innocence claims is so demanding that only a handful of prisoners will be able to satisfy it, end quote. At the end of the day, you can see that there are exceptions in the current system, and I believe the exceptions are great, but they don't fulfill the job. Hundreds of individuals are still being denied access to justice every year solely because 1 year has gone by. Now, the next point of argumentation brought up by the negative team was essentially talking about the purpose of the statute of limitations. And he brought up this idea that the purpose of the statute of limitations is to preserve evidence, to make sure that the evidence introduced before the court is timely evidence. And while I would agree that in general, it's nice to have timely evidence before the court, the life and liberty of individuals should be weighed much higher than the timeliness of evidence. According to the United States Court of Appeals for the Ninth Circuit, on April 29 of 1963, in Sanders v. United States, they said, quote, but its roots would seem to go deeper, Conventional notions of finality of litigation have no place where life and liberty is at stake and infringement of constitutional rights is alleged. If the government is always to be accountable to the judiciary of a man's imprisonment, access to the courts on habeas corpus must not thus be impeded, end quote. This really goes to show that sure, finality of evidence is something that we generally should strive for. But when individuals' life and liberty is being stripped away from them, that should be weighed as a much higher standard. Now, I'd like to end with our justifications as unconstitutional, and if I have time, I'll go into unjust. So in 1974, the Supreme Court decided in Wolf v. McDonald that, quote, in view of the importance of writ of habeas corpus, it is fundamental in our constitutional scheme that access of prisoners to the courts for the purpose of presenting their complaints may not be denied or obstructed, end quote. The Supreme Court, the sole arbiter of the Constitution, ruled in United States, Wolf v. McDonald, that obstructing prisoners' access to the courts is unconstitutional. The statute of limitations is by definition obstructing prisoners' access to the courts, and therefore unconstitutional practice. Now, finally, I don't have time to read a card of evidence on the unjust point, but essentially the card of evidence says that individuals often lack the proper resources to mount an effective challenge, or they don't even realize that there is a time limit on their access to justice, but either way, they are being unjustly denied access to the courts and their lives are being stripped away.
Starting off, can you tell me how many cases are thrown out unjust?
Around 130.
That's just the number of cases that are thrown out.
Every single one of those cases is unjust.
So any case that's thrown out is unjust?
Because it is their fundamental constitutional right to habeas corpus. Whenever you deny or obstruct it, that is unjust. No matter on the merits of the case, the fact that they don't get access to the courts is simply unjust.
What is access to the courts specifically?
Access to the courts is unobstructed access to the courts, and Wolf v. McDonald ruled that in view of the importance of writ of habeas corpus, it is fundamental that prisoners' access to the courts may not be obstructed.
Okay, you talked about how this is an unjust law specifically, and that exceptions don't prove that it's a just law. So explain to me, how is this an unjust law? Is it the idea that we should never impose a limitation on justice?
Yeah, it's an unjust law really for two reasons. First of all, you can look to the Constitution because it is a fundamental right of prisoners to have habeas corpus. But furthermore, hundreds of individuals have their lives stripped away simply because a year has gone by.
Okay, and again, out of those hundreds of individuals who aren't allowed to bring these cases, you actually can't show us how many of them would be released from prison or how many of them would be successful.
Well, obviously we can't show that because they never made it to courts and nobody knows their merits.
You would agree with me though that the past precedent has showed that only about 3% of habeas corpus petitions are successful.
Yeah, it doesn't matter, and that's existent within the current system and existent within the affirmative team's plan. The fact is that they're being denied access to the courts, and that is their fundamental rights, and innocent people are being denied access to prove their innocence.
So I'd like to go back to this idea of what makes a law unjust. Now, if it is just a limitation on justice, wouldn't that imply that every single statute of limitations is unjust?
No, I'm not at all saying that. I'm saying that this specific statute of limitations is
Sure, but
unjust,
specifically-
because of the constitutional requirements.
Right, but one of the reasons you provided that is unjust is that it places a time limit on justice, and you would agree with me that that's what every single statute of limitation does in the current system.
Yeah, I think other statute of limitations might not have the exact same requirements. This one is specifically 1 year, and again, individuals often lack the proper resources to mount an effective challenge
Okay,
within that.
so then we can agree that just having a restraint or a time limit on justice doesn't necessarily make a law unjust, correct?
I don't think I can make a claim on that general idea, but specifically to this statute of limitations, because it is a fundamental constitutional right, and because their lives are being stripped away without even access to the courts, yes, it is unjust.
Okay, and again, we can agree the purpose of habeas corpus is that innocent people will not be in prison, correct?
Generally, yes, so
Okay.
that the prisoners can actually have access to the courts.
And then specifically in terms of innocents who are in jail, you only read 2 examples, correct?
Yeah, obviously we can't.
Okay.
We can read more examples if you
Do you have any numbers as to how many people are wrongfully imprisoned by our justice system?
Again, they never made it to the court, so we have no idea.
But you would agree with me that
how many
past
are
precedent would show that's only about 3.2%, correct?
3.2% of them are innocent, that is correct. But every single one of them that is being denied access to the courts, that is an unjust thing.
The current system is a just system. It's a simple philosophy. We can look at examples and we can look at extrapolated circumstances, but we cannot say a law is unjust from specific circumstances. Today, Nathaniel and I asked a few things. We want to see if there's an actual problem in the current system. In today's second negative constructive, I'm going to be looking at whether there's an actual problem. Before I do that, I'd like to look at a few burdens of proof, or things that I believe that the affirmative team must show. The first is that these claims that are being denied should not have been denied. Now, they are saying simply from the fact that there's a 1-year statute, they should be being heard in court, and I'm going to be getting into that more later. But they have failed to show in any way, shape, or form that these people being affected by the 1-year statute of limitations should have been able to completely get around it. There's a reason that there is a statute, and I'll be getting more into that, but they have failed to show an injustice in regards to the people actually having their cases thrown out. We can understand that because of past precedent, we see that before the ADPA statute of limitations became in place, only 3.2% of people were filing meritorious claims and were actually successful. And now they're claiming that all of them that are being thrown away are somehow ones that are meritorious. The problem is that because of past precedent, we understand that that's simply not the case. However, these people are still getting to court, which we'll talk about soon. The second burden of proof that I'd lay on them is any sort of expert or court case where it's been found to be unconstitutional. They claim that it's unconstitutional, it violates the Constitution, but have failed to bring in a single court case where it's been weighed and found unconstitutional. In fact, the fact of the matter is that it's not, and we'll be getting into that in one of my main points. But before I do that, I'd like to make 2 specific clarifications. The first you can write down is suspension different from limitation. Suspension different from limitation. Now, Nathaniel agreed in his cross-examination that a suspension would be a complete blockage, and the statute of limitations does not do that. It provides a correct amount of time for somebody to file, and then limits that right to file after the statute of limitations is over. They would claim that it is a complete suspension, but that's not what it is. It is rather a limitation, and the courts have found that as well. But the second clarification that I'd like to make is that all prisoners still have access to court. Their main claim is that it's unconstitutional because these prisoners do not have the right to access the court in the first place, but that's simply not the case. I'll refer you back to the examples that they brought up, or of Morales or any other that they brought up. Those were thrown out by the judges and thrown out by the courts because they failed the statute of limitations standard. All of these cases are still getting to courts, and those prisoners are presenting their evidence in what's called an evidentiary hearing inside the court. They're failing to show that these people are not actually reaching the court, which is their whole harm. The thing is that they actually do reach the court in the current system. Now, the first main idea that I'd like to get into you can tag is not unconstitutional. And we're going to look at when the statute of limitations has been weighed in actual court. And there's actually 60 years of supportive case law around this whole idea. Harvard Law Review says this on February 10th of 2016, quote, "What is clear is that the AEDPA and 2255 have so far been upheld as constitutional. Even beyond the canon of construction that Congress intends to legislate constitutionally, 2255, as it stands, has the benefit of more than 60 years of supportive case law," end quote. What we can understand is that it has been upheld as constitutional in the court of law and has never actually been found that it violates the Constitution. The affirmative team would posit that it's unconstitutional, but fails to show that in the court of law. Let's look at the Supreme Court specifically. And Harvard Law Review talks about the case of U.S. versus Hayman. And it says this, quote, "In United States versus Hayman, the court's first investigation of 2255's constitutionality, the court indicated that the statute's savings clause, which allows a petitioner access to habeas corpus proper when the 2255 remedy is inadequate or ineffective, obviated the need to address 2255's constitutionality, end quote. So it talked about how it needed to evaluate it further because it came up in this case. They evaluated it further in the case of Swain v. Presley. This is according to the same article in the Supreme Court. Quote, "The court treated 2255's constitutionality more thoroughly in Swain v. Presley. The court focused its attention on the savings clause again, finding that the only constitutional question presented is whether the substitution of a new remedy, which is both adequate and effective, should be regarded as a suspension of the writ. Citing Hayman and its implicit holding that such a substitution is not a suspension, and noting that both 2255 and the District of Columbia statute were exactly commensurate with habeas corpus, the court held that neither statute amounted to a suspension under the suspension clause," end quote. They recognized that because of something called the savings clause, or a way for them to get around the 2255 statute of limitations and various ways that my partner was talking about they can get around it, it does not violate a writ of the suspension of habeas corpus. When the court evaluated, they found that it did not violate the Constitution. In fact, in Felker versus Turpin, they finally evaluated it again, and it says this, quote, "When the AEDPA was brought before the Supreme Court in Felker versus Turpin, the court held that because an original writ of habeas corpus may be filed in the Supreme Court itself, the AEDPA did not unconstitutionally suspend the writ," end quote. It's explaining that because habeas corpus claims can get to the Supreme Court, that it is not a suspension of the writ, and the Supreme Court found that themselves. John H. Bloom, writing for Cornell Law Review, actually did a total evaluation of suspension of cases that were thrown out before the statute of limitations came in and cases thrown out after the statute of limitations ended. He looked at 10 years before the statute of limitations was implemented and 10 years after to see if the success rate was a big change and to see if it actually was effective. And here's what he found. Quote, "The court decided 63 pre-AEDPA habeas cases. The habeas petitioner, the inmate, was successful in 33% of those cases. There were 41 Supreme Court cases that were governed by AEDPA, or after it was implemented. The habeas petitioner was successful in 34% of the post-act decisions. Thus, a habeas petitioner's overall success rate did not significantly change after the AEDPA came into effect," end quote. At the highest court in the land, the Supreme Court success rate did not change after the suspension clause, or rather after the statute of limitations was put in. So we see that there's no constitutional violations as Cornell Law School finally impacts, saying this in December of 2021. Quote, the AEDPA's restrictions on successive petitions for prisoners are well within the compass of an evolving body of principles restraining abuse of the writ, and hence do not amount to a suspension of the writ within the meaning of the clause," end quote. So we can understand that it is not a suspension of the writ, but the final point I'd like to get to is that it's not unjust. It's not unjust. The first is that statute of limitations are important. According to the Corporate Financial Institute, quote, "The main reason for creating statute of limitations is to prevent potential defendants from being subject to unfair prosecution. One concern that gives rise to statute of limitations is the simple fact that after the passage of many years, relevant evidence may well have been lost. If so, it can unfairly hinder either the prosecution or the defense and lead to an unjust verdict. People's memories fade and become less reliable over time, and it is considered unreasonable to expect witnesses to be able to recall details from an incident that may have occurred decades earlier," end quote. So we see the purpose of it, and specifically, we see the purpose of why the statute of limitations was put in this specific motion. According to Douglas Glade from the Florida Bar, he says, quote, "Congress obviously intended to impose a one-year statute of limitation for the filing of federal habeas claims by prisoners. The purpose of the statutory reform was to curb the lengthy delays in filing that were occurring in federal habeas corpus litigation, while preserving the availability of habeas review when a prisoner diligently pursues remedy and applies in a timely manner," end quote. There is a reason Congress put this in place. It does not violate the writ, and every time it's been evaluated in court, it is found that it does not do so. The current system is both constitutional and just.
First of all, congratulations on making it to quarterfinals. I just a few questions for the major points you brought up. Now, first of all, regarding your first burden of proof, you said that claims should have been denied, and you mentioned that only 3% of the claims are actually meritorious. So how is this situation better in the current system than under the affirmative plan? Because the fact that the claims are not meritorious.
Correct. So what happens in the current system is that there's a statute of limitations made so that the meritorious ones and the ones that are pursued in a diligent, timely manner are actually weighed upon. But I shouldn't say weighed upon because, as I talked about, the cases are actually going to court in any circumstance.
Okay, now your next point of argumentation is essentially talking about how all prisoners still have access to the courts, and I think you were saying that it's different between suspension and limitation. And would you agree, I read a part of evidence from the Supreme Court that said a simple obstruction of prisoners' access to the courts is unconstitutional.
Actually, you talked about a Wolf v. McDonald case, which was well before the habeas corpus claim was ever, or rather the statute was put in place. So that's never been weighed. In fact, it has been weighed and it was found to be constitutional. But in Wolf v. McDonald, I don't believe it was directly applicable to the writ of suspension.
But it did say in habeas corpus, and in view of the importance of writ of habeas corpus, the simple obstruction is an unconstitutional.
I'll go back and look at that evidence, but again, after it's been weighed, after the 1-year statute of limitations in the Supreme Court, well after Wolf v. McDonald, they found it to be appropriate.
Now, under your constitutionality argument, you brought up the Harvard Law Review, essentially talking about how generally the AEDPA has been upheld as constitutional. Now, would you agree that Harvard Law Review is actually a planned advocate for a case that says the statute of limitations is unconstitutional?
Actually, I wasn't reading any opinion by the Harvard Law Review. I was reading the Harvard Law Review directly citing Supreme Court cases.
Okay, now I'd like to go into those Supreme Court cases. Did any of them talk about the statute of limitations?
It was actually talking about the 2255 statute of limitations, yes.
So it talked about 2255 and it talked about AEDPA. Did they mention the statute of limitations?
I can go back over the evidence, but I believe that one of the main portions of 2255 is the statute of limitations, and if they're evaluating it, they're evaluating the
And
whole.
you would agree that Nathaniel and I are saying that the statute of limitations is what's unconstitutional, not 2255 and the AEDPA.
Well, the 2255 includes the statute of limitations, so if it's weighed on, then it's weighed on in the Supreme Court.
All right, now your next point was talking about how success rates do not change. Now generally you would agree that hundreds of people are still denied or obstructed access to the courts, correct?
I would agree that people are being denied under the statute of limitations. But as my partner talked about, there's statute of limitations everywhere in civil law because it's a normal thing to have a statute of limitations and be denied to a certain extent under that standard.
All right, then your final argument was talking about how statute of limitations are important because they preserve the finality of evidence. And would you agree, I read a part of evidence in my speech that said that life and liberty should be weighed higher than the finality of evidence?
I do agree with that, but again, statute of limitations exist everywhere and it's for specific reasons that we talked about.
All right, thank you.
Today's debate around justice has been presented as the highest one. Effectively, the question before you is the current system just? There's also been a question of constitutionality, and we'll cover both points in this speech. First, looking at the issue of justice. Before I get into that, I want to propose one quick thing to the affirmative team. And this is really the burden and the standard that they have in today's debate round. They have to show a significant harm. That harm has to be in regards to innocent people. This entire debate round, they have talked about how innocents are harmed by the statute of limitation, but all they've shown you are 2 examples. And so if they want to show you that people are actually harmed, they have the burden to prove that there is an injustice and there is an unconstitutionality happening in the current system. And so far in this debate round, they've shown me 2 examples which do not prove the harm. Next, moving into the idea of justice. Now, under the exceptions that I brought up in my last speech, Luke had 2 main responses. First was that exceptions to an unjust law do not make that just, and the second was essentially that they're rarely used. We'll cover those both in turn. First, under the issue of exception. Now, I pressed this hard in cross-examination, but it essentially came down to this, that their whole argument that the law is unjust comes down to the fact that it places a time limit on justice. And by that logical standard, every single statute of limitations would be unjust. But that's not the case. Statute of limitations exist all over the United States and have constantly been used by
by the courts because it leads to a higher standard of justice. They may get up here and talk about the constitutionality, that every individual has the right to a habeas corpus claim. But underneath our Constitution, every single one of us in this room has the right to access the court system. And under the idea of statute of limitations, that would essentially be putting a limit on justice. But we see that that alone does not make an unjust law. And as such, the law is not unjust. They would further have to prove this. The second thing we can talk about is the idea of rarely being used. And here's essentially what this comes down to. It's rarely used because it's rarely needed. But let's look at the cases where it is actually used. According to the Douglas Jerem, the attorney at Florida Attorney General's office, he wrote saying, "The clause merely states that one-year time limit periods of limitation shall apply, and does not contain any restrictive language that would imply a limit on federal court jurisdiction." So essentially what this says is that the court has jurisdiction over these claims. But let's further look at how this has been used by the court. Specifically on these exceptions, according to the Harvard Law Review, writing in February of 2016. They say, "One could easily conjure sympathetic cases where the statute of limitations seem particularly unjust. For instance, a prisoner may have been given the life sentence based on aggravating factors, only to have these aggravating factors overturned in a later decision. Or the prisoner may have challenged the effectively impossible. And in fact, courts have used their equitable powers to make some allowance for particularly sympathetic cases for prisoners." So courts use the exceptions to allow prisoners to access the court and have their habeas corpus petitions heard. Here's what we can see. The exceptions are used when they are needed, and the system is just. The issue of constitutionality was covered by Caleb, looking at court precedent over court precedent over court precedent that proved that the ADPA, and specifically Section 2255, is constitutional. Now they will get up here and say that that was not referring to specifically the statute of limitations, but it was a review of Section 2255, and that includes the statute of limitations. The court has ruled it's constitutional, and it is not unjust. With the last minute of my speech here, I'd like to further impact how this creates an unjust system, because I think this is incredibly important. The affirmative has made the case to you that the system is unjust, but the opposite is absolutely true of their policy. Statute of limitations are put in place for a reason. Only 1.8% of prisoner cases result in them being let out of prison. And there are tons of cases filed by prisoners. So what is the impact of all of this? Well, you can write down a couple of different impacts here. The first is frivolous cases. Frivolous cases. The individuals who file cases before the ADPA, as the evidence that I talked about, said that these were filed 10 years, even longer than 10 years after the conviction had happened. But the reason we have the statute of limitations is to limit these frivolous cases. Because when they're allowed to file from any period, the success rate is only 1.8%. And that 1.8% that we could possibly assume is the harm are allowed to be heard in the current system, because there are exceptions that are used when they are necessary. As we can see, the current system is just. The current system is constitutional. There's no need for it. Thank you.
We start our testimony in 5 minutes.
statute of limitations failed its own goals, but it succeeded in taking away the constitutional rights of prisoners and unjustly imprisoning the innocent. Throughout this speech, I'll be responding to the negative team's arguments they made in the last speeches, showing you that the statute of limitations is an unnecessary, unconstitutional, and unjust policy. So my first main point, you can tag this as unnecessary. Now, they were talking about the statute of limitations is needed for finality in cases in order to preserve evidence. But what they did is they completely ignored my partner's response, and he brought the piece of evidence from Sanders versus United States, ruled in Supreme Court that finality has no place where life, liberty, or where life and liberty are at stake. So we see that we should hold justice and unconstitutionality over the finality of evidence. They also talked about how frivolous cases can and overflood the court through the results of our plan, but they completely ignored my partner's response in his first speech, saying that the statute of limitations failed its own goals, and as a result, all the statute of limitations, there was an increase of petitions in the district courts. By getting rid of the statute of limitations, we will not flood the courts with frivolous claims, because we see the statute of limitations actually increase frivolous claims because of it. Now, moving on to my second main point, you can write this down, is unconstitutionality. Now, Caleb's first point was talking about how the suspension is different than limitations. Now, you can tag my response, a suspension happens after limitations. Suspension happens after limitations. Now, the suspension clause provides exactly two reasons why you can suspend the right of habeas corpus, rebellion, or invasion. But in the current system, after the limitation has run, they're simply denying it simply because 1 year has gone by. That is a suspension of the suspension clause. Now, the second point was also that all prisoners have access to the courts and that they can bring their evidence to an evidentiary hearing. But my response is simple, that he did not bring any evidence to actually back up this claim. Now, they also talk about, brought up a lot of case law. They talk about there's 60 years of case law backing up this case. And he talked about U.S. versus Hayman and Swain versus Presley and Felker versus Turpin. So in regards to U.S. v. Hayman and Swain versus Presley, those were regarding 2255 motions as a whole, not the statute of limitations. In regards to Felker v. Turpin, that was the AEDPA as a whole. They were testing the constitutionality of the entire act. They were not specifically taking a look at the statute of limitations. Now, they were saying that the statute of limitations is inside the 2255 motion. It's a big part, therefore they were ruling on the statute of limitations. The statute of limitations is one of 7 parts of the 2255 petition text. They're not ruling on the statute of limitations, they're ruling on the 2255 motion as a whole. In response to all the constitutionality arguments, first of all, we see in Wolfe v. McDonald, there's been no Supreme Court ruling specifically on the statute of limitations, but in Wolfe v. McDonald, prisoners' access to the courts cannot be obstructed in regards to habeas corpus. But secondly, there has been a district court ruling specifically on the statute of limitations. According to Robert Workman Sweet, who was a United States District Judge, said on June 24, 1998, he ruled that, quote, Nicholas Rosa, who filed a habeas corpus petition from an order of the United States District Court for the Southern District of New York, Robert W. Sweet Judge, denying the state's motion to dismiss on the ground that the petition is untimely. He goes on to say that the district court ruled that the state's motion to dismiss could not be granted because such a dismissal would violate the statute suspension clause of the Constitution, unquote. So he specifically rules that the statute of limitations directly violates the suspension clause. My third and final subpoint, you can tag this as not the two reasons. Now, we have two conflicting court cases, and I'd like to show you why you should see this as a suspension of the suspension clause. Now, there are two reasons why you can suspend habeas corpus: rebellion or invasion. Essentially, the court's ruling was saying that there is a slight chance under these exceptions that you can get habeas corpus, and because of this slight chance, we're not completely suspending habeas corpus. But my reasoning is simple. Justice is giving every man his due, not just in extraordinary circumstances, and not just where there's a slight chance of actually getting an exception. We see that the statute of limitations is an unconstitutional practice. And finally, this leads me to my third and final main point of unjust. Now, even if the affirmative team can prove that this is an unconstitutional constitutional policy, it is still an unjust policy. They talk about how it's not all meritorious claims. My response is simple. Habeas corpus is also for the manifestly guilty. And according to the Harvard Law Review, it says, quote, but access to habeas corpus should not be premised on whether a case is particularly sympathetic. The suspension clause does not limit its protection to those with meritorious claims. It preserves habeas generally. The benchmark protections of criminal procedures exist primarily to protect the innocent, but they also apply to the manifestly guilty, unquote. So they are talking about there's a 3.4% chance of an innocent, 3.4% of innocent people actually get habeas corpus, but it also applies for the manifestly guilty. Justice is giving every man his due, not just for the innocent people. They also talk about the success rate is also the same, and regardless of whether the success rate is still the same, after the statute of limitations, hundreds of cases are still being brought every single year. In regards to all the exceptions, the half measures do not cure the defect. Simply because there's a slight chance of getting an exception does not justify having this law in the first place. And for all these reasons, I strongly urge an affirmative ballot. Thanks so much.
Starting wrap time at 17 seconds.
Quote, since the passage of the AEDPA, courts of appeals have rejected arguments that 2255 statute of limitations constitutes a suspension clause violation, end quote. When we look at what is unjust and when we look at what is unconstitutional, we look to who makes those rulings, the court. And whenever the courts have weighed the statute of limitations or 2255 motions which encompasses that statute, they have found that it is not an abuse or suspension of the writ of habeas corpus. Today we're going to look at two main voting issues, that it's not unconstitutional and that it's not unjust. Let's go ahead and look at the idea of constitutionality first. They've essentially been claiming in today's debate round that the statute of limitations is a suspension of the writ of habeas corpus. However, they have failed to bring any court case law or any law that rules on the statute of limitations and says that it is a violation of the writ of habeas corpus. They did bring one up in their last speech, and we went ahead and reviewed that. And we actually found that the judge used one of the exceptions that we've been talking about to get around it. The district court ruled in this instance, he filed, and the district court ruled that the state's motion to dismiss could not be granted because such a dismissal would violate the suspension clause of the Constitution. But it talks about earlier in the article, quote, Rosa filed a habeas petition less than 1 year after the effective date of AEDPA. The state argued that the petition was barred by the AEDPA because it was filed some 10 years after Rosa's conviction had become final. They were using one of the exceptions because new evidence in this case had been found and the court was able to rule on it. What we understand is that it's not unconstitutional because the courts have the ability to go around these instances of an unfair, in case of an unfair situation with the statute of limitations. Let's talk about some specific cases that we talked about. First of all, Felker versus Turpin, and they said that was talking about 2255 as a whole and not the statute of limitations. Well, my first response is that 2255 as a whole has been found to be constitutional. Inside of 2255 is the statute of limitations. They're saying that because that specific part was not ruled upon, then it must be unconstitutional. But every time the whole 2255 has been weighed in court, it's been found to be constitutional. Specifically in Felker versus Turpin, the evidence that I read said this. Quote, the AEDPA hindered prisoners' access to the habeas corpus remedy. When the AEDPA was brought before the Supreme Court in Felker versus Turpin, the court held that the AEDPA did not unconstitutionally suspend the writ. Let's take a look at the other one I brought up, Swain v. Presley, and it says at the end of the article, quote, the court held that neither statute, talking about 2255 and another one that they were weighing, neither statute amounted to a suspension under the suspension clause, end quote. What you can understand is that statute of limitations are not suspending the right, but merely limiting the right in a just and appropriate manner. And then next, I'd like to talk about the success rate. We can understand if it's actually been unjust if we see the success rate changing of those who are filing cases. But this man who did an analysis, writing for Cornell Law Review, looked at 10 years before the AEDPA and 10 years after the AEDPA was passed, and he found the same exact success rate. Understanding that those with meritorious lawsuits are either receiving exceptions or are filing their claims in an appropriate manner. We understand that because of the success rate in the Supreme Court, it has not actually caused a problem of injustice or unconstitutionality. The last idea I'd like to talk about is that of not unjust. And we've been asking throughout this round, is there any statistics? How many of these are being blocked because they should not be blocked? We understand that statute of limitations exists everywhere in civil law, so the question of injustice comes down to whether these claims should be blocked. And they've been able to bring up about 2 different examples of 2 different individuals who are blocked in an unfair manner. But they have failed to show a systemic or significant harm in the current system, merely positing that it is an unjust law, but not been able to prove it. In fact, it's been proven by the courts that it is not an unjust law and not a suspension of the writ of habeas corpus. But next we understand why the statute of limitations exists in the first place. And I read this piece of evidence to you earlier, specifically regarding why it was passed. According to the Florida Bar Association, quote, the purpose of the statutory reform was to curb the lengthy delays in filing that was occurring in federal habeas corpus litigation, while preserving the availability of habeas review when a prisoner diligently pursues remedies and applies for habeas relief in a timely manner, unquote. What it does is it stops the lengthy delays and the delays that were happening, thus causing unjust ruling because memories fade, and that's why statute of limitations exists, but remaining and leaving the remedy in place so that we can understand it still remains. But last of all, we understand that the courts still have jurisdiction. I'd like to reread this evidence that went unresponded. Quote, the clause merely states that a 1-year time period of limitation shall apply, but does not contain any restrictive language that would imply a limit on federal court jurisdiction, end quote. The statute of limitations exists, but in situations where federal courts want to go around it, they have the jurisdiction to do so, and the statute of limitation does not tie their hands. Because the current system is not unconstitutional and not unjust, we ask that you negate the resolution today. Thank you.
The affirmative team will be starting to time at 69 seconds.
Jeffrey R. McDonald was convicted of the murders of his pregnant wife and their 2 young daughters. McDonald has steadfastly maintained that he was innocent of these horrific crimes, untimely failed to have his convictions overturned. As part of his most recent effort, McDonald secured the 2255 motion, which asserted a Fifth Amendment due process claim based on the newly discovered evidence of former Deputy U.S. Marshal Jim Britt. In addition to the Britt affidavit, the memorandum incorporated numerous exhibits, including the affidavits of 3 other witnesses swearing that Helena Stocky's boyfriend Greg Mitchell had confessed to murdering the McDonald family. But by its opinion on November 4th of 2008, the government had moved to strike exhibits from 2255 motion, the 3 affidavits describing confessions made by Greg Mitchell, because the evidence is untimely. Here's one final example of an individual who was denied access to justice. Their lives were stripped away simply because a year had gone by. This is they keep asking us if this is a systemic issue, and yes, it is. Hundreds are denied access every single year to the prison, to habeas corpus, and they're saying that how do we know if these are actually meritorious claims? How are these actually an unjust denial? Every single one of those denials is an unjust denial because one, it is a fundamental constitutional right in our suspension clause, and furthermore, their lives are being stripped away. Now, in this final speech of the affirmative team, I'd like to synthesize our argumentation into 3 main voting issues. Essentially, the 3 main reasons why I believe we must pass the affirmative team's policy proposal today. And they mirror the points of argumentation that my partner made in his last speech. You can tag my first voting issue as unnecessary. I'd like you to recall back to my first speech when I read a card of evidence that talked about how, as a result of the statute of limitations, 2 things occurred. 1, the number of petitions actually increased, and 2, the amount of frivolous cases increased as well. And generally, this has gone unresponded to by the negative team in their last speech. So at the end of the day, by increasing or by getting rid of the statute of limitations, there's not going to be more frivolous cases or more cases in general. There's not going to be a court flood. They keep talking about how only 3% of the cases are meritorious. Well, as a result of the affirmative team's plan, it's not like we're going to be flooding the courts with frivolous cases. Actually, the opposite result will occur. There will be less cases within the court. Now, my second voting issue today is unconstitutional. Now, they keep bringing up court precedent. Essentially, they bring up court precedent of United States v. Hayman, United States v. Presley, Felker v. Turpin, and again, my response is the same. It's not in the statute of limitations. They said that statute of limitations is included within 2255, and I would agree. But they dropped my partner's response that there are 7 different sections within 2255. The statute of limitations is just one of those. The older court precedents don't even mention the statute of limitations, and they don't say that it is constitutional. The statute of limitations is unconstitutional. So what do we do when the Supreme Court doesn't have a decision on whether or not the statute of limitations is unconstitutional, whether or not it is constitutional? We go to the next highest court, and that's the circuit court. Now, what did the circuit court actually decide? Well, the circuit court decided that the statute of limitations for 2255 is an unconstitutional practice. Now, the negative team responded to this by saying that, well, actually, the court precedent was citing an exception, and they were talking about the new evidence exception. I would completely disagree. Nowhere in that evidence did it say that there was a new evidence exception. All it said is that he filed 10 years later. It's completely irrelevant, and the section or the exception was not there. So the fact is, when you look at the highest court available ruling on the statute of limitations, it says it is an unconstitutional practice. Now, I'd like to get to my final voting issue today. That is unjust, and I believe this is the most important point that we should consider in today's video. I think we can look at the stories of Angel Morales, we can look at the stories of Floyd Perkins and Jeffrey R. McDonald, who are individuals who are being denied access to justice simply because a year has gone by. And these people were innocent people, but it really doesn't even matter if they were innocent or not. It doesn't matter on the meritoriousness of their cases, because it is a fundamental constitutional right that you have access to the courts and you have access to habeas corpus. When hundreds of individuals are being obstructed their access to habeas corpus, that is an unconstitutional and unjust practice.